this is Aditi and you are watching Legal Bites. Our today's topic of discussion is vicarious liability. In this video, we will be talking about introduction to vicarious liability, meaning of vicarious liability, what are the essentials of vicarious liability, principles of vicarious liability, relations which are governed under vicarious liability, and at last we will be taking an important question. Now let's start our video. Our first topic is introduction to vicarious liability. Now what is vicarious liability? Vicarious liability is a theme of law of torts. Basically, we can say that someone else will be held responsible for the acts and omissions of others. Now coming to meaning of vicarious liability. Vicarious liability is a doctrine that assigns liability for an injury to a person who did not cause the act himself, but who has a relation with the person who did act negligently. For example, Mr. X works as a pickup driver in a school. His main work is to pick up the students from their home and then to drop them at the entrance of the school. Now what happened? One fine day, while he was on the course of employment, he hit the lady. That lady claimed for damages. But as Mr. X was working on behalf of school authority and as the accident took place during the course of employment, the school authority will be held responsible. Now coming to the essentials of vicarious liability. The first essential of vicarious liability is there must exist a relationship between the parties, be it master-servant, principal agent or partners in a partnership firm. The second essential is the wrongful act should be committed by someone else. The third essential is the wrongful act must have been committed during the course of employment. Now this essential has a leading case law. State Bank of India versus Shyama Devi. Now what happened in this case was the plaintiff's husband has a neighbor cum friend who works in State Bank of India. One fine day, the plaintiff's husband handed over some money and checks to his friend in order that he would deposit the amount in the plaintiff's account. Although no official receipt was received, later on, it was found that there was some misproportion in the amount, but it was held that as the employee was not working in the course of employment and as he was working for his own profit, the plaintiff will not be entitled for any kind of legal damages. Now coming to principles of vicarious liability. Basically, there are two principles. The first one is respondent superior and the second one is qui fecit per allem feci per se. Now what does respondent superior means? Respondent superior means let the principal be liable or let the superior be answerable. It is a principle in tort law that holds employer liable for all the wrongful acts committed by the employees during the course of employment. Now what does qui feci allem feci per se mean? It means he who does an act through others is deemed to have done the act himself. Basically, it means when a servant commits an act, it is considered as to be done as per the master's order, and consequently, it is as same as the master has done the act himself. Now coming to relations which are governed under vicarious liability. There are three relations: master-servant relationship, principal-agent relationship, and partners in a partnership firm relationship. Now, what does master-servant relationship means? Before understanding this relationship, we need to understand who is a servant. A servant is a person whose service is appointed by the master and whose main work is to follow and abide by the commands given by the masters, and the relation developed between them is termed as master-servant relationship. This relationship has leading case laws. The first leading case law is Sitaram Motilal Kalal versus Shantanu Prasad Jaishankar Bhatt. It was held in this case that a master will be vicariously liable for all the acts of the servant. Our second leading case law is Limpus versus London General Omnibuses. Now what happened in this case was the driver of the defendant company was clearly instructed not to take participation in any racing activities and not to obstruct any other omnibuses. Yet the driver of the defendant company willfully and against express orders of the company took active participation in racing, and not only this, he also obstructed other omnibuses of the plaintiff. It was held that the defendant company will be liable for the driver's act, as the driver's act of driving the omnibuses was within the course of employment. Our third leading case law is Peterson versus Royal Oak Hotel Limited. What happened in this case was the plaintiff was a customer who, on being intoxicated, was refused from further drinks by the barman who was employed by the respondent hotel. This action by the barman made the petitioner furious and he threw a glass. The barman picked a piece of glass and threw it back at him, which in consequence hit the eyes of the plaintiff. The respondent hotel was held liable for the barman's act, as the respondent hotel had master-servant relationship with the barman. Now coming to our second relationship that is governed under vicarious liability, that is principal and agent relationship. When a principal authorizes his agent for an act, he becomes liable for the act as the agent has committed the act in the course of performance of his duties. This relationship has a leading case law, Omrod versus Crossville Motor Services Limited. Now what happened in this case was the owner of the car asked his friend to drive his car. While the car was being so driven by his friend, it collided with a bus. The owner of the car was held liable. Lord Denning in this case observed that it is the sole responsibility of the owner to whom he gave the charge of the vehicle, be it his friend, his servant, or anyone else. If the vehicle is partly or wholly used for the owner's own purpose, the owner will be held responsible. Now coming to our third relationship which is governed under vicarious liability, that is partners in a partnership firm relationship. Section 25 of the Indian Partnership Act states that every partner is liable for all the acts done in the firm while he is a partner. For any tort committed by any of the partner in the normal course of business of that partnership, every other partner will be as responsible as to that who is in fault. The liability thus arising will be jointly and severably. This relationship has a leading case law, Hamlin versus Houston and Company. What happened in this case was one of the partner of the firm bribed the plaintiff's clerk in order to gain some confidential data. It was held that since one of the partner of the firm breached the contract and being in a partnership, it makes every other partner jointly and severably liable for the breach of contract. Now coming to an important question. Mr. X has appointed Mr. Y as his agent, and during the course of employment of Mr. Y, he commits a fraudulent act. Now, who will be held responsible and why? Support your answer with a relevant case law. As we can see, there is a principal-agent relationship between Mr. X and Mr. Y. And as we have studied earlier also, principal will be held liable for the acts of his agent. So here also Mr. X will be held responsible for the fraudulent act of Mr. Y. This relationship has a leading case law, Lloyd versus Grace Smith and Company. Now what happened in this case was Mrs. Lloyd, a widow who owned 2 cottages, was called at the office of Grace Smith and Company, a firm of solicitors, in order to consult them as she was not satisfied with the income she was having from her property. There she was attended by the managing clerk of the firm, who advised her to sell those property and made her sign sealed deeds. But in reality, that was not sale deeds, rather it was gift deeds made in the favor of the managing clerk himself. The House of Lords held that as the fraudulent act by the agent was committed during the course of employment, the firm will be held responsible. If you like this video, do like, share and comment. Thank you.